I'm Brian Clark, and we are going to be talking about the very sexy topic of legal issues for affiliate marketing. May not be the most exciting topic, but it's really exciting to stay out of trouble either as an affiliate or a merchant. So, and it's getting more complicated all the time from a regulatory standpoint. So we've got some very smart people here today that I'm going to introduce to you that are going to kind of help give us some guidance on what we can do. A little bit about me. I run Copyblogger.com. It's a site that has about 140,000 subscribers. We basically teach people content marketing and copywriting. In essence, we teach people how to sell things online. And these are the guys who either look to get us in trouble or keep us out of trouble. But I'm moderating this panel because in my former life I used to be an attorney, and thankfully I'm not now. But I do have a background in commercial litigation before I started marketing online in the late 90s. So I've been very lucky to at least be somewhat aware of where the line was and not to cross it. But like I said, you know, there's legislation being passed all the time. There was a bill passed at the end of the law that caught a lot of, at the end of the year, that caught a lot of people off guard. And I had to get up to speed on that. And I would imagine all of you would like that as well. So let me introduce our panel here today. At the far right, we have Thomas Cohn of Venable, LLP. He is an attorney who represents merchants, affiliates, networks, counseling them in order to stay on the right side of the law and defending them when they accidentally cross the line. In the middle, strategically placed, is Dean Graybill of the FTC. He's the guy that represents the agency who has a very noble cause to stop bad things from happening, consumer protection, et cetera. Sometimes these laws have unintended consequences and we need to look out for them. So where you think you might be perfectly on the up and up, you might accidentally cross the line, and he's going to help give us some common sense guidance there. And right here on the other end of the FTC sandwich is William Rothbard, who is a former FTC attorney who now, like Thomas, also counsels and defends people almost exclusively in the FTC action area. Thomas also does state of California legal issues at the state level, which is a different discipline all in itself. So basically what we've got here is, because this is kind of a complicated area, instead of a normal panel discussion, the guys have put together some really great slides to kind of make the concepts easier to understand. And then we'll all kind of chime in as appropriate. We'll have obviously we have the counselors who keep you out of trouble perspective. We have the FTC perspective, and then we've got my perspective, which is, please don't come after me, FTC. All right, so do you want to come up here and run us through the first? You want to do it for me? Okay, perfect.
Hello, everybody. I'm going to control this thing for the first half, and then I'm going to pass it to Tom. And we're going to go through the slides and touch on every slide, some more than others. And Brian and Dean and Tom may chime in from time to time with questions or observations. And we'll try to save as much time as possible for Q&A after the presentation, because that's where the discussion can be most productive. So starting here, we're going to try to cover today the FTC's powers, which are to regulate deception and unfairness. It's a very, very broad, somewhat vague mandate, and is applied to different cases, different fact situations, and by the FTC, which is a very, very small agency in Washington. I call it sort of the Sugar Ray Robinson agency of D.C. It's pound for pound maybe the most powerful law enforcement agency in Washington, D.C. So a small agency with a very, very broad jurisdiction and with very, very strong powers of enforcement. We're going to touch on the FTC's and the State Attorney General's priorities for enforcement. We'll cover briefly some developments in the area of substantiation of advertising claims, and also the meaning of clear and conspicuous disclosure, also in the negative option context, which is a very, very controversial and timely issue. And just keep in mind as we go through this that the FTC statute really is all about substantiation of claims and disclosure of material terms and conditions in a clear and conspicuous way. So those are the two touchstones really of FTC enforcement in this area. But again, the devil is in the details and the application of those standards to facts. And then we'll cover the revised FTC endorsement guidelines. There were some changes in those a year ago, and the FTC has begun to enforce them against companies. And then we will touch on merchant advertiser liability, affiliate network liability, and best practice compliance tips, which hopefully will be of some interest and value to all of you. And then if we have time, we'll touch on developments in the area of mobile marketing, including text messaging in particular, and privacy, which is a very, very important and hot area, but also a very vast area. I'm not sure how much time we'll spend on that. So on the deception side, the FTC enforces the law against claims that are deceptive in that they would materially mislead consumers who are acting reasonably in the circumstances. It theoretically is designed to protect only consumers who are acting, reasonably, ordinary, reasonable fashion, and not consumers who are uneducated, gullible, vulnerable, which used to be the standard a long time ago, but was changed back in the 1980s. However, within certain subgroups of consumers, for example, the elderly, or desperate homeowners facing foreclosure and being marketed with home loan modification offers that seek to help them but take advantage of their situations, the FTC will focus on those groups of consumers and try to protect them because they are in a very vulnerable, desperate position, and they've done so a lot in the last 2 years in the wake of the Great Recession and the crash. State of mind is irrelevant in liability for violating the FTC Act. You don't have to intend to violate. You don't have to have knowledge of the violation to be held liable. If the FTC or court finds an ad to be misleading, it has the power to issue an order against the defendant for liability. When it comes to monetary remedies, the FTC can get a monetary remedy, including redress, disgorgement, civil penalties against a company that's been found to be liable. But if the Commission has sued the individual, the principals of the company, in order to get an order that holds them liable for redress monetarily, they have to prove that the principal had knowledge that the ad was deceptive or was indifferent, recklessly indifferent to the truth or falsity of the ad. Go ahead.
Yeah, I'd like to just emphasize, again, I'm Dean Graybill with the FTC. I'm supposed to give these disclaimers that I'm not speaking for the commissioners, just for the staff. I just want to emphasize one point about the individual liability part. Our base, as Bill will point out, the FTC, we're not a criminal agency. We don't have the authority to bring criminal laws. What we can do, however, and what we do routinely do, is to go to federal court in the name of the FTC versus the defendants. We very often will ask the court for, if it's a severe enough case, we will ask the court for the authority to freeze defendants' assets, for injunctions saying to see no more. In extreme cases, we can ask for a receiver, a court-appointed representative of the court to take over the company temporarily. Now, again, the defendant can always come in then and get all that lifted if they can prove that we had it wrong. But there's one thing I think business people may not fully appreciate always. Any business corporate law would say an individual officer or owner is shielded by this idea of, the corporate veil. It's important to be aware of that in the FTC Act, we can name the individuals, and as Bill said, there were specific, you can get monetary liability from the individual officers for the acts of the corporation. Now, we can't just do it willy-nilly. We do have to prove, as he said, that there's actually not only that they knew there was wrongdoing, or there was a reckless disregard, or they had an awareness of a probability of fraud and an intentional avoidance of the truth. I think that it's important to recognize that part, because I can't tell you how many times we've faced individual defendants whose main defense is, hey, we compartmentalize things. I didn't know about those consumer complaints. I don't read the complaint file. I don't talk to my consumer representatives. That sort of hear no evil, see no evil approach to running a business is not going to get you far. And I just want to emphasize that point.
Yeah, no, what Dean says is right. But sometimes, the deception may not be clear on its face. I mean, in cases of outright fraud or very, very clear deception, the principal won't have much of a defense so that he didn't know that it was deceptive. But there can be gray areas involving implied claims or situations where the principal thought that the company had substantiation for the claim, and there's a debate over whether the substantiation is adequate, and maybe the commission can convince the court that it wasn't, and find liability. But the defendant might be able to convince the court that it had a good faith, credible belief in the truth of the claim or the substantiation, and not hold that principal liable monetarily for redress.
I'll just add that, well, first of all, I think it's great that the FTC representative had to start with a disclaimer. I mean, even they have to do it. So, yeah, I mean, it makes a good point. As a CEO who also writes copy, I'm still on the front lines of this, and that's where my legal education has served me well, but it's getting much more difficult to keep up as things evolve. But the good thing is that means our industry is growing up and being taken seriously, so there's two ways to look at it.
And then the second prong of the FTC's authority is to regulate, quote, unfair actual practices, which is even more vague and nebulous than deception, and which is not used very often in advertising cases. But to prove unfairness, they have to prove, quote, substantial consumer injury, physical or economic. In the privacy area, there's some budding discussion of perhaps finding violations of privacy based not on physical or economic injury, but injury to reputation or injury to, quote, consumer dignity, has been mentioned by FTC officials, but it's all very preliminary. Basically, the law still is substantial economic or physical injury that cannot be avoided by the consumer acting reasonably. It's not outweighed by benefits to consumers or competition. But again, it's rarely used in advertising cases. There is an unfairness allegation in the FTC's very recent case against iWorks, a big case in the area, where they allege that there was, quote, unfair unauthorized billing of allegedly forced upsells. But by and large, the FTC is a deception agency and enforces the law on the basis of that authority. Generally speaking, the same standards of deception and substantiation apply to all products and to all media, including online media. But there is a sort of a hierarchy of substantiation standards for certain types of products and claims, with claims of health and safety, or claims that that the dietary supplement is, quote, clinically proven, which is called an establishment claim, need to satisfy the highest level of substantiation, which the FTC usually says is controlled clinical studies proving the efficacy of the product. Dean's already covered some of this. Essentially, this slide outlines the FTC's powers to enforce remedies. The ones here that are most significant and can cause the most misery in a marketer's life are the remedies for bans and bonds, which can basically banish someone from his or her livelihood for a lifetime or for a certain period of time. Usually is required for a second violation, but for a violation of an order that someone is already under. But again, in certain cases, including this new iWorks case, my understanding is that the FTC is seeking lifetime bans against the defendants in that case, even though this is their first time in an FTC matter. And then, of course, the power to go into court without notice to you and ask the judge, the federal judge, to issue a temporary restraining order, including an asset freeze, appointment of a receiver, and basically taking over your business and cutting off your own personal as well as corporate access to your assets, such that you can't even go to the bank and withdraw money from the ATM. So it's not a good situation to find yourself in. Unfortunately, Tom and I represented a number of folks who are in that position, and it's pure misery. So,
can you tell? Oh, I'm sorry. Go ahead.
I would just quickly point out that, as it might have just sounded, it's a pretty, severe remedy right off the bat to bring a lawsuit. And I should point out that for us to persuade a court to do that off the bat, we have to have a lot of proof up front. And if you look at the filings that we filed with the federal courts, they look about a foot thick with declarations from consumers, background information on the defendants, the websites themselves, whatever disclosures that were made or not. So it's all there. And it doesn't mean that the judge at the end of the day will agree with us if it goes to trial. But we have to, for any of that severe initial relief to be granted, we have to carry our burden of proof.
They do, although sometimes what a quote, a lot of evidence means is, is debatable. I've been involved in cases where they've put in half a dozen declarations of consumers, which was enough to get the judge to enter a TRO. But whatever the amount of evidence that the FTC puts in, 9 times out of 10 or 10 times out of 10, the judge is going to enter the TRO. And if there's an asset freeze or receiver as part of the relief, that goes into effect before the defendant has even had a chance to walk into court, and really puts the defendant behind the 8 ball.
You've mentioned this iWorks case. Can you give us some details about what that involves so people have an understanding?
Yeah, sure. iWorks was, I think it's out of business now, but for many years became a very, very large advertising and marketing agency, advertising and marketing its own products, grant programs, Google money-making, business opportunity programs, and marketing them through affiliate networks, and including with the core offering of the grant program or the BizOp upsells of various types. And it became a very, very large business, and the FTC opened an investigation of it a year and a half ago. It didn't go into court right away and seek a TRO. It investigated it, and I guess apparently thought that it had was in violation of the FTC law, and they weren't able to settle, and so they brought sued in federal court in Nevada in late December, alleging that the company's negative option offers and upsells, which the FTC alleges to be forced upsells, kind of bundled with the core product without disclosure that they're part of the offer, and allegedly false, or not false, but blogs providing positive reviews of the products that allegedly were planted by the company, and with the bloggers receiving compensation for the blogs, which implicates the FTC's endorsement guidelines that Tom will cover in a bit. So it's a very high visible case because iWorks became such a big internet marketer doing hundreds of millions of dollars in revenue. And I think the FTC used it as a sort of a signature case to hold one of the largest marketers in the online space liable for violating the FTC Act, and if they're successful, getting a big money judgment against the company.
And one thing I'd point out about it is the iWorks case is really, it's almost a core paradigm of many of the cases that we have brought into this area. And that is, you get this paradigm of the companies, first of all, the defendants themselves have a web of companies that have their own websites. Then they also may induce, other affiliate marketers beyond that to carry certain messages. But the core offer is, we have a free trial offer of, in this case, it was, you can get of a product that shows you how to get government grants to pay for personal expenses, like fixing up your house, etc. Or secondly, there will be the typical biz op, money-making sort of thing. And it'll be free trial, except paying shipping and handling. And it's for that ostensible purpose that they get your bank account information or your credit card information. And then what you don't realize when you sign up for the free trial is that that banking information will then be used to bill your account for some other offers that you never quite saw because they were so inconspicuously disclosed. And this is very, very typical, continuity memberships in for which you will be, in this case, you were charged one big sort of fat fee of a couple $100 and then a monthly fee until you told them to stop charging you.
And there was no option to choose or not choose that separate service. It was allegedly buried in the fine print, if at all, and that's what's termed a forced upsell, basically. Not opt-in, not opt-out. It was just if you paid the shipping and handling for the thing you thought you were buying to try, you automatically got charged the hefty membership fee for the forced upsell.
So again, it boils down to whether or not the offer, the terms and the disclosures were, quote, clear and conspicuous. A very broad term that will be litigated in that case, as in other cases that go to court, over whether or not that that standard was met in that case.
Yeah, so I mean, continuity business models are fantastic if it's clear that's what you're selling. I mean, we sell an SEO service that's monthly billing, but that's what we sell. And this, in this case, was, look at this, oh, and this is buried over here, and we're going to bill you till the end of time. There may even be allegations that when you try to end the service, they didn't quite end it.
They don't answer the phone.
Right.
That sort of thing. And there's so many variants of this, and I could name you 10 different cases with 10 different variants. Sometimes there's a upsell offer below the main submit button that's been pre-clicked. And you'd have to see that and unclick it, not to be billed. Or there's one case we have in our office right now where, and this would be really the affiliate marketer who, for another third-party merchant, sort of presented the offer in a sort of 4-panel small print thing where only one of the 4 blocks was pre-clicked. And even though it was above the submit button, we would allege thousands of consumers, skipped over that because they were sort of induced to skip over it and thought they were just getting a payday loan. I mean, there's so many different, pre-clicking, where you place it, the colors you place it. The fact is, in all of our cases, almost all of our cases, there's a quote disclosure, some ostensible disclosure. I don't know why. I think people think that they've jumped through some legal hoop or that's going to deter the FTC from suing them, but it's the insufficiency of those disclosures, the legalese, right. the million words, the placement exactly where it's not, doesn't look important. That's the heart of so many of these abuses.
Yeah, pre-clicks can be deceptive, and I don't recommend them to my clients. But there can be a case where the client wants to use a pre-click and does have a pre-click, but it's clear and it's conspicuous. The consumer can easily see it, And next to the box, there could be language saying, if you don't want this offer, then unclick this box. So that could be a case that involving a pre-click that would not be, at least in my opinion, necessarily misleading, and hopefully the FTC wouldn't challenge it. Yeah.
Just say it is okay to have it already clicked a box. Is that what you're saying? Or is
A pre-checked box is not okay.
It's not a good idea.
Generally speaking, it's not. Yeah.
Yeah, I mean,
box?
anytime you're asking someone to opt out instead of opt in, you're probably trying to slip something by, right? It's like
And
the
conversely,
mom
yeah.
test. Like if your mom thinks you're doing something wrong, you're doing something wrong. It's the gray areas where it gets really difficult.
Yeah, I mean, I think if there's a pre-check, but there's that is clear and conspicuous, and there is a statement next to it saying, if you don't want this offer, uncheck this box, and that's equally clear and conspicuous, I would argue that that's not.
But in reality, they usually aren't. Yeah.
It's okay, but it's not the best.
Right, exactly. Moving on, these are some areas that of active FTC enforcement. Financial offers, the Great Recession and the market crash spawned a lot of new offers to consumers experiencing financial anxiety in many different areas. So the FTC and the state attorneys general over the last 2 years, and especially in 2009, brought literally dozens, if not hundreds of cases against grants, internet biz ops, home loan modification services, debt relief, tax relief, seeking to control companies that allegedly were seeking to take advantage of consumers who were in great financial distress as a result of the economic.
What you might call the recession vertical or the poverty vertical.
Right.
The FTC places a huge top priority on that and has done so for the last 2 years.
Right. Another big area that we've been talking about already is negative option continuity, discount membership clubs, upsells, dietary supplements, acai berry. It's been a very hot category. Weight loss claims are a perennial popular category for enforcement. Colon cleanse products have become very popular and therefore attracted FTC attention in the last 2 or 3 years. And most recently in the weight loss area, HCG is now being marketed more and more heavily, and I expect will get the attention of the FTC and the states in due time. Free offers, free trial offers without disclosure of the strings that are attached to the offer are a perennially important area of enforcement. Affiliate deception and fraud. The FTC has brought cases against affiliate network, including the one that Dean just mentioned, involving switch marketing and others. Can spam, sending out emails that are deceptive or don't have the opt-out mechanism in the email. Privacy and new areas. One is called penny auctions. I'm not sure how many of you have heard of penny auctions, but it's a new hot area online that basically where a consumer basically can register with the site for free and then buy bid packs and bid small amounts of money on auctions of very attractive popular merchandise, iPods and iPads and things like that. And if they win, they get the merchandise, but many times they don't win and they spend a lot of money and don't win, and sometimes the rules of the game aren't disclosed properly, or the game could be manipulated or even rigged by the site. So it's an area that because of the way it's been burgeoning and attracting a lot of consumer dollars, could be a target for enforcement. Just very generally, we mentioned substantiation. The FTC requires, quote, competent and reliable evidence to support advertising claims for certain types of claims, including health and safety claims. They require appropriate scientific evidence, which can be in the form of clinical studies, either on the actual advertised product or on the ingredients in the product. And in this area, one issue to highlight is that the FTC last year got a settlement with a company called Iovate that changed the competent and reliable scientific evidence standard for weight loss claims for dietary supplements, getting rid of the flexible, competent, and reliable evidence standard, where the evidence, where the type of evidence or the amount of it could vary from case to case, and requiring Iovate, the party to that settlement, to have at least 2 controlled clinical studies on the actual product done by separate independent researchers. A very, very onerous and arguably, rigid standard for proving weight loss claims that has never been required and is not yet official FTC policy, but reading the tea leaves, it's possible that the FTC has decided internally that this new standard, this new 2-controlled clinical standard, is at least for weight loss supplements, will be the de facto official substantiation standard for that category going forward, and that in future, in ongoing or future weight loss cases, they will require that the marketer agree to that standard as a condition of settlement, and if it doesn't agree, then they'll litigate it in court. And then another case called Palm Wonderful, the big health juice maker. It was sued by the FTC for making allegedly deceptive claims for its health juices and not having adequate substantiation because allegedly its product was not approved by an FDA monograph. So again, moving from the very general, competent, reliable evidence standard to much more narrow, specific, arguably rigid, one-size-fits-all standard of substantiation. Yes, sir.
In each one of these cases you're talking about, every single one of them were asset seizures?
No, not necessarily. In neither Iovate or Palm Wonderful was there a TRO and an asset seizure. They were.
That's not standard operating procedure for the FTC.
No, not for national advertising cases like those, but for what the FTC feels is hardcore fraud, sometimes it is typical. Dean can.
Yeah, I mean, it's hard to generalize. If you on the one end of the continuum, historically, there's been like if Kraft, says there's so much milk and cheese, if you look historically, that was an administrative case. It's brought in our administrative court. There isn't any asset freeze. Okay. On the other end, practically all these internet cases that involve these continuity plans, they're really trickery into getting your bank accounts and then charging you for something that you didn't even know you bought into. Those are invariably federal court, and we go for as severe things as we can. I wish I could give you a brighter line as to when things are on one side and the other. We have also brought in federal court with asset freezes cases against companies making extreme weight loss claims for like bogus diet pills, Hoodia, all that stuff. I mean, so it depends on the severity, I guess is the best way to say it. Which brings us quickly to, I just want to make just a general point about clear and conspicuous doctrine in FTC law. And it's funny, this is just from years of dealing with defendants and their counsel who, people have been at the FTC before. They understand, I think, intuitively what we're talking about. But you get the sense that many people in the internet, not many, but a segment of people in the internet marketing, they have this idea that disclosure, it's almost like this legalistic hoop you jump through, and if you jump through it, that's all you gotta worry about, then sell. And then there may be analogies in other state laws, where there's these mandatory disclosures you gotta make, and as long as you do that, you're home free to do, FTC law is not like that. And it's very, very important that people have just a basic concept. The one gospel I preach about FTC law is that it is a common sense prospect. It is your duty as the advertiser to make an educated assessment of the message that is being conveyed in total, the net impression, including disclosures, including all of it, including the color, the music, the drama. You've got to make, I mean, people are in the business of marketing. I mean, they use all these elements to say things. Well, they have to use that same acumen to determine whether the net effect of what they have conveyed is deceptive. And FTC law, Bill's absolutely right. People are being just absolutely, consumers are being idiotic and reading things into the ad that just aren't there. We won't bring a case like that. But our law says that even if it deceives a significant minority of consumers, who knows what that means, 15%, whatever, the advertiser can be held responsible. But here's the important thing. And people often are a little frustrated, I think, with us because they want a bunch of black and white rules. Well, there's something called the .com disclosures document, which has been on the FTC website for I don't know how many years now, 10 years, has a lot of good practical advice in much detail. But the real message is use your common sense. If you've said something that there's a powerful central selling message, like let's say you're doing one of these, I'm going to save your home from foreclosure messages, and it gives you this impression that we succeed, we get an insight with the banks, we succeed, we're going to intervene for you and all this stuff. If you got a central message like that, it's not good enough to have on page 10 in the FAQs, oh, what is the likelihood of my house being saved? We don't know. Results may vary. And it turns out that they don't save any homes, or they save 10%. Yeah, you wouldn't sell it to your mother. I mean, it's important to think holistically about your ad, and this whole idea of a central message and then sort of taking away from the message, almost in a contradictory way, in some less dramatic way, on page 2 of your ad or whatever. That's just a recipe for trouble. And other than that, I'd like to tell you that there's a black and letter law about placement of things in ads. You honestly have to step aside and be objective about your ad. And because I tell you, we've seen ads, like I said, every case has a disclosure in it. And I don't know where people got the idea they can make the disclosure that small, or that misplaced, but there's color, how easy do you see it? The use of boring legalese. There's some types of disclosure that have been used so much people don't pay any attention to them anymore. Believe it or not, that's your duty to think about that aspect, because the point is to get a message across to your live audience. So you got to think about placement. You got to think about what the consumer is paying attention to, likely. If they think they're getting a payday loan and they aren't interested in these little ancillary offerings and they're going to the submit button and that's what they're likely to do, and there's something pre-clicked up there, that's common sense that you're asking for trouble, in my view. So anyway, that's it.
And Dean uses the word ad there, so just so there's no misunderstanding, a blog post and an email that pre-sells an affiliate offer, that's an ad, okay? Don't think it's different because it's content. You're driving traffic, that's an advertisement, and that's where the whole affiliate disclosure rules come in, and we'll talk about that a little bit later.
Congress, however, has, at least in one area of disclosure.
Go back one.
Oh, I'm sorry.
Okay.
Given us one area of guidance that's very specific. The Restore Online Shoppers Confidence Act known as the Rockefeller bill, passed Congress unanimously, basically, in late December. It was signed by President Obama before the end of the year.
Raise your hand if you got shoe money scare email about how this was the end of affiliate marketing, right? Okay, it's not, but let's tell you exactly what it's about.
Anyway, there are two parts to this new law. On disclosure, for all negative option offers online, and the law applies only to online sales, not to offline sales. For all negative option disclosures online, the terms of the offer have to be disclosed, quote, before obtaining the consumer's billing information. So no longer for negative option offers will it be adequate to disclose clearly and conspicuously, necessarily at the order button. It's got to be spatially in some way, quote, before the fields where the consumer enters the billing data. So that's one part of it. Second part of it is that it prohibits transfer of account data, of billing account information, from an initial merchant that has done a transaction with the consumer and charged the consumer's credit card, debit card, bank account, and then passed that account data to a third-party, quote, post-transaction merchant who, until this law was enacted, could take that account data and use it to transact the upsell and not get the account number from the consumer again, all over again. This law prohibits that transfer and requires the third-party upseller, the post-transaction merchant, to get the full account number from the consumer again, as well as to make clear to the consumer that it is different from the initial merchant. So it's a significant law that will have a real impact on online marketing, and should be understood by by marketers that are passing account data between each other for purposes of that data being used to authorize second, third upsells.
Does everyone understand what a negative option is?
No.
Okay.
Oh, I'm sorry.
Okay, so Columbia House, remember when you sign up, they send you the CD, you have to send it back or you owe them money for it, right? I have so many bad CDs because of that program. That's a negative option, where they deliver you something and then it's up to you to take some form of action before a certain deadline, or you will be billed and you will owe that money. And then the data transfer issue is it does affect affiliate marketing in the sense that it's a little bit more sophisticated marketing method, more of a joint venture type thing. So for example, you've got Merchant A, they sell you something, you hit the thank you page, and Derek, I know that you know that psychologically people are in the mood to buy a little bit more when they've just bought, right? So those thank you page sales go really well. And so Merchant A is actually handling the transaction for an affiliated partner who's providing that service. And then of course, this merchant wants that customer data. They want the customer in the sale. That's no longer allowed.
If the merchants are affiliated in a legal sense, that is that there is inter-ownership or control between the companies, then it doesn't apply. It only applies to data transfer between unaffiliated merchants. And then there's a new law in California that applies to negative option / continuity that's worth noting very quickly, that requires for all negative option offers in California, the terms have to be, quote, larger than the surrounding text, or, quote, clearly contrasted or set off from the surrounding text. So just as the Rockefeller as law applies a new standard for negative option in terms of placement of the terms, the new law in California applies a new standard in terms of presentation or prominence of the terms. So with that, I'm going to pass the clicker to Tom, who's going to talk about endorsement guidelines and other topics.
Thanks. Thanks, Bill. The FTC has a set of guides on endorsements and testimonials that they originally came out with almost 30 years ago. And then a little over a year ago, they finally issued a revised set of guidelines. These aren't laws or regulations or rules, but they're just really business guidance on how to comply with the FTC Act, how to comply with the law. And they have guides in other areas too. But the endorsement and testimonial guides are important to online marketers because whenever a claim is made through somebody else's voice, a testimonial, an endorsement, basically those are treated just as if the advertiser was making the claim itself. And basically, the claims being made by those in endorsements and testimonials have to be, truthful. They can't be false. They can't be unsubstantiated. And you can't put in somebody else's mouth what you, as the advertiser, couldn't say yourself. The two major changes in the revised guides that came out, I think, November of '09, the two changes are really in bold here. One was the FTC thought that the advertisers had really run a truck through this loophole, which is basically, being allowed to say results not typical or results may vary whenever you made an outlandish kind of outlier sort of claim about results from taking the product or using the product or whatever. And basically the FTC said that sort of safe harbor of saying results may vary is really not going to suffice any longer. And now if the claim conveyed is that result being advertised as typical, then you have to actually disclose clearly and conspicuously what the generally expected results are. So now advertisers are trying to wrestle with that to maybe massage the claim a bit so that maybe that atypical result is no longer portrayed as the takeaway by the consumer. And now advertisers' challenge is to maybe, if they don't have substantiation for the claim they're making, maybe they need to tone it down or portray a wider variety of results so that the takeaway is no longer the extreme or outlandish sort of result. But that's an ongoing issue. I don't think the FTC has brought a case yet on this particular part of the revised guides. They have, though, brought a case on the second major change, which is disclosing material connections between the advertiser and the person giving the endorsement or the testimonial. Material connection is, what would a consumer expect or not expect from, the claim being made by the endorser or the person giving the testimonial. If money's being paid or free products being given to make that endorsement or testimonial, that's usually a material connection that has to be disclosed. And a couple examples that the FTC has done since the revised guides came out, and this is important with blogs, review sites, articles, lots of different content that affiliates publish. There was sort of an investigation followed by a closing letter that sort of had a warning in it, but no enforcement action was taken, involving Ann Taylor stores, where there was an instance where people were given a gift to blog about the new collection. And the advertiser didn't follow up to make sure the bloggers disclosed that material connection. They quickly, stopped it and said we won't do it again. We'll have better procedures in place to monitor and make sure our bloggers make those disclosures in the future. So the FTC closed it and said, we expect better monitoring and making sure your bloggers disclose that connection. Then they followed that a few months later with a case against Reverb. This involved actually a PR agency that sent out its own employees to basically post, positive reviews, and and basically didn't disclose that these statements were being made by the employees of the PR agency for the client, the advertiser. So that company was put under order and enjoined from failing to disclose that material connection, basically. So there may be more cases in the future on online marketers and not disclosing payments, freebies, and other material connections when a blogger or any other type of endorser, person giving a testimonial, gets that and doesn't disclose it. And now I'm going to just talk about looking at advertisers, networks, and affiliates, and who's liable, who isn't liable. I assume most of you are affiliates, but is anyone here actually an advertiser, selling a product, selling a service? Okay. I mean, basically, it's anyone and everyone in the stream of commerce involving online marketing could potentially be liable in a state attorney general action or an FTC action. It's not just the advertisers. It could be the affiliate marketers. It could be the networks. It really could be anyone, like a PR agency with Reverb. It could be anyone who's sort of in that chain. And basically what the responsibilities are, we've covered this already, claim substantiation, clear and conspicuous. But let me just move on to affiliate and network liability. Is anyone here actually with a network? Okay. I mean, you probably know already, but if you don't know, I'll just remind you now or tell you now that the state attorney generals and the FTC, it's safe to say, are investigating. They've brought lots of cases against online advertisers. You know all about those cases, but they are investigating large affiliates and large affiliate and not so large affiliate networks as well. So basically, affiliates and networks, I mean, email marketing, yes, can spam, but also, the state and the feds are also looking at, who else may be liable. If you just take, what's in the offer from the advertiser and you just use that, are you okay? Well, not necessarily. I mean, there could be false and unsubstantiated product claims in there, and so affiliates can be liable. Networks can be liable as well if they're taking an active role in creating content for the advertisers or for the affiliates as well. So basically, I think even the Consumer Protection Director at the FTC, recently gave a speech where he basically warned that, that advertisers have to monitor the affiliates on the front end as well as the back end, kind of know who you're doing business with either directly or indirectly through a network. And then on the back end, look at who your top affiliates are, you advertisers, and if they're top, kind of look and monitor and see why they're top performing. Are they publishing deceptive content, with false and unsubstantiated claims? So looking at overlapping advertiser and affiliate network liability, we use the term cross liability here, but basically what we're talking about is, like I said before, anyone in the stream of advertising could be held liable. And basically it's, it's incumbent upon, I think Dean mentioned see no evil, hear no evil. If you're not a product seller, but you're sticking your head in the sand and you as a network or you as an affiliate aren't really paying attention to what you're getting in terms of the offer content and what you're republishing, there is conceivably liability up and down the chain. And in terms of actual enforcement actions, this started many years ago actually when CAN-SPAM first came out. The FTC and state AGs did bring actions against affiliate marketers in the email marketing area, in the ringtones area. Probably know about the Florida AG there. And then they kind of followed that up more recently with some actions against affiliate marketers who actually in their sponsored search results that they published for makinghomeaffordable.gov, which is an Obama administration program for foreclosure prevention. The sponsored search result had the entire government URL right there in the sponsored search result. So the FTC charged that they were being deceptive and unfair and basically misdirecting consumers who were looking for that government program to paid foreclosure rescue sites and paid mortgage modification sites. So they went after 7 or 10 or 12 affiliate marketers, and I think all but one are now under order in federal court actions. So, and then we mentioned here in the slide about Florida settlements, New York AG settlements with discount membership. We talked about discount membership clubs and deceptively upselling those. In terms of affiliate marketing, also with both the FTC and the state AGs, they're going to look at false and unsubstantiated, claims. They're going to look at, falsely implying celebrity and major media endorsements or connections that don't exist. So those are false claims themselves. You probably know about the Oprah Dr. Oz action from, I think it was August of '09, going after many advertisers and many affiliates for misrepresenting endorsements by Dr. Oz and or Oprah of different products like acai berry. So anyway, it's the playing field is a lot more dangerous now than it was even a year and a half, 2 years ago. The FTC is getting much more aggressive. They're looking way beyond just the advertisers themselves. And so that kind of brings us to some top 5 tips for affiliates. Obviously fake blogs, fake news articles, fake review sites, very, very, very high risk. And just running a fine print in the bottom saying, not a real person, not a real news site, not a real review, it's not going to be enough to trumpet X and then fine print at the bottom say not X. That won't cut it with either state attorney generals or the FTC. And then in terms of merchants and networks, I would just leave you with these tips. And obviously don't infringe on personal copyrights, trademarks, other intellectual property. If we have any time, do you want to just jump in and say anything about mobile marketing and privacy? I'll leave the last 2 slides to you.
We're almost out of time.
Yeah.
And so maybe we'll skip over.
Mobile.
Are people interested in okay. Very good.
Mobile? No.
I want to ask you,
Yeah.
the 3 of you, to weigh in on something, and we talked a little bit with Dean
Sure.
in the hall, because the number 1 question I get ever since it was made clear that we have to disclose compensation when we're endorsing a product. I mean, number 1, let's make sure everyone understands what endorsement means. Basically, it means you're affirmatively telling people to buy it as opposed to, say, putting a banner ad up, okay? The number 1 question I always get is, well, what kind of disclosure is good enough? Do I have to disclose in the content? Can I put it at the bottom? Can I have a site-wide blanket disclosure? We always disclose in the content, and I even encourage people to turn it into a copywriting thing where you turn it into a positive thing, like, hey, you can trust me, I'm being upfront with you. But I want to hear from you guys, specifically Dean, and then what you guys are thinking about. What disclosure is enough?
Sure. I mean, Dean can jump in, but we had a slide many minutes ago on clear and conspicuous and the 4 Ps: proximity, placement, presentation, prominence. It's really the same common sense advice even in this area too. The endorsement or the testimonial is the claim. So if there's anything that later on that is going to modify that claim, such as they got paid or results may vary, and the generally expected results are actually going to be X, not what the endorsement or the testimonial said. Anything to modify the claim that was made has got to be as clear and conspicuous as the claim itself.
FTC orders, if a company is under an FTC order, advertising order that involved the disclosures, the word that the FTC typically puts into its orders to define clear and conspicuous is, quote, unavoidable. The disclosure must be unavoidable. So, taken literally, that would mean that the disclosure would have to be in the most prominent place possible on the page or in the commercial. But that's how the FTC enforces the standard.
As noticeable as the claim that it's modifying. So,
It's gotta be in the-
whatever the endorsement of the testimonial looks like, and
Yeah.
the net impression, that the
So you can't
takeaway.
have a little link in the footer that says disclaimers where you disclaim the fact that you're being paid for everything. And there are people who do this, and some of them. It, in my opinion, doesn't cut it. It's, but if it's in the content, even blended in, it's actually can become the selling point where you're saying, look, I'm being upfront with you, but I wouldn't recommend this if it wasn't great, and I don't, if I don't use it myself, whatever.
Yes, sir.
I just had a fast clarification opinion. On the Rockefeller law, if you're a credit card processing gateway who's to be compliant with these MasterCard Association rules, they're holding the credit card data. Does it mean that the consumer still has it if it's a third party?
They are not a merchant.
No, I understand the merchant's using, merchant A is using the
as I understand it,
Consumer have to, is it?
The whole key, okay, so here's why marketers want to do this. They want to sell two things at one time with one transaction because conversions go up, right? If you make that person do a new transaction where they enter a credit card all over again, data is transmitted only to merchant B instead of being shared between merchant A and merchant B, conversions go way down. But what they're doing is sharing customer data, and that's what's no longer allowed.
Merchant A that charges a credit card cannot pass that data to
Any customer
merchant B
data.
directly or through its processor or any other agent that's holding that data.
That's
Right.
my
No. Right. If the processor is acting as an agent for the merchant.
And Visa and MasterCard were requiring this
Right.
a year before the Rothbard law
Right.
passed anyway, so.
Right. But again, if the credit card has not been charged by the first merchant, if it's a lead gen site and it's taken someone's account number and referred it to, let's say, a lender, and that lender did not approve the consumer and the card was not charged, and then that lender or the lead gen site passes the data to another lender, does that second lender have to take the account number again, or can it pre-populate its site with the account data that they got from the first site because it had not been charged yet?
What's the answer to that? You don't know?
The way I read the statute, the requirement that the second merchant get the number again from the consumer applies only if the card has been charged in the first transaction. That's how I read it.
Okay.
Do you protect customers against international companies which are not located in the U.S.?
The FTC only has jurisdiction over companies that are selling to American consumers in this country.
Although Dean can talk about the Safe Web Act and.
Yeah.
Go ahead.
Yeah, I mean, basically, they did change the law a few years ago to actually make it possible for the FTC to work together with international authorities and actually go after companies in the U.S. that are selling to foreign consumers if they have substantial operations, if the unlawful practices are occurring in the U.S. And so that can cover online marketers, certainly.
Yeah, so if the practices that are unlawful are happening here, or if the product is being sold to consumers here by a company here or offshore, then the FTC jurisdiction would apply.
And aside from the law, we're always trying to have sort of reciprocal arrangements with other foreign consumer protection agencies. The most obvious ones, for example, Canadians for years in telemarketing. You'd have telemarketers from Montreal selling gemstones down here, and we would sort of bring, with our Royal Mounted Police, we would bring mutual action. So there's both the Safe Web Act, but also just we're trying to recognizing that the internet, of all things, is just borderless.
Right.
We constantly are trying to meet with our counterparts in other countries to deal with that.
Go ahead, one more.
Is your team big enough? Is your team big enough? Because there are millions of web pages and...
Is our agency big enough?
Yeah.
It's never big enough.
What's amazing is that the FTC, if I am correct, is maybe half the size that it was in absolute numbers of personnel today than it was 25 years ago. Because in the 1980s, it was just wasted during the Reagan years with deregulation, and its budget and its resources have never recovered from that, even as the marketplace has expanded through the internet and other ways to become.
It's a small agency. There's 1,100 people. Look at the cabinet departments are huge. FTC is tiny, but you don't want to take the risk of being the one that they choose in their prosecutorial.
Exactly. You don't want to be made an example of, because that's what they'll do to scare everyone else.
In boxing parlance, we punch above our weight.
As I said, the Sugar Ray Robinson of
Yeah.
enforcement.
But also, I tell you, it's one thing, we try to leverage our resources by working with other law enforcement partners, like the 50 attorney generals. I mean, I tell you, when this whole scourge came of all these firms promising to save your home from foreclosure, pay us $2,000 and I guarantee you we'll save your home. I mean, there were hundreds of those firms. Well, by the time we brought 60 federal court cases against that alone. And beyond that, we formed task forces with regulators in California and other states where, and the FBI, and it got to a point where we were all stumbling over each other to get targets. So part of it is, we pick our battlefields to some degree and like pour resources into that. And it's like, it's a little bit of a left hand, right hand, trying to get away with it all, but.
Last question? Yeah.
Going back to the pre-checking of upsell, how do Norton antivirus, when you go to buy their software on their website, it clearly states it's $79.99. You click add to cart. You go to the cart and they automatically add something else into your cart called Norton download insurance for $8.99. And it's not very clear that you can remove that.
How do you remove it, actually?
You have to click this little trash icon, which is in gray, might as well be white, I can barely even see it, on the right of this particular add-on. How do they get away with that? I mean, Norton's a big company.
Sounds like a good FTC investigation.
Oh, right.
To me.
Norton is going to be sending Derek a thank you letter later on.
Not having seen it, I can't
I
opine.
actually paid for the $8.99 download. I realized after the fact, I was like, what the hell is this?
I bought McAfee recently. I didn't experience that, so that's interesting.
I think you just given Dean an idea.
Bill thinks that's legal.
No, yeah.
I'm kidding.
All right, guys, we're out of time, so thank you very much. Appreciate it.
Thanks.